And good morning. And good morning, Your Eminence.
Good morning, Judge. How are you today?
Fine.
All right. So before I call my docket, I'm just going to let you call this case. And I've got Miss Husky. She is there on Zoom. I don't know if you can see her or not, Judge, but Mr. Murleader is present, Mr. Green, and Miss Husky, your prosecutor. So you can go ahead and call this case when you're ready, Judge.
Yes, sir. Okay, this is State of Texas versus this cause number 19232, State of Texas versus Michael Ray Green. This hearing is set for the purpose of addressing any pending pretrial motions and to set the case for a trial for a day certain. Yesterday, the special prosecutors or the attorneys, prosecutors pro tempore were sworn in and the documents have been filed. Counsel, you ready to proceed, Madam District Attorney?
Yes, Your Honor.
And counsel for Mr. Green, you ready to proceed?
Yes, Your Honor. Shroud Murleader for the defendant, Mr. Michael Green. We're present already, Your Honor.
Okay. Are there? I had to ask the court coordinator to email me any pending pretrial motions. The district attorney, I think, thought there was at least one defensive motion or somebody had filed a lemony motion, but I do not have copies of it yet, so I do not know what those might be. Are there, from the state, are there any pending pretrial motions?
Your Honor, the state has not filed any pending pretrial motions. However, I do intend to file the standard motions such as expert witness list, a motion for defense's disclosure of expert witnesses, and my state witness list.
Counsel, I assume all of you by now have my email address. If you file something, I would appreciate if you would send me a courtesy copy of it because I'm not on the e-filing system for Van Zandt County.
Yes, Your Honor.
Counsel for the defense, do you have any pending motion that's been filed?
Yes, Your Honor. Just to address the state's pending motions, we do not have any expert witnesses, and I do not anticipate having any expert witnesses for trial. And I wouldn't have an objection to the state's motion for expert witnesses. We received a copy of that. We've also received a copy of the proposed notice of the state's experts, as well as the proposed state's witness list, which is yet to be filed. Your Honor, prior to the prosecutor pro tem being appointed, I had filed the defendant's application and motion for community supervision. Mr. Green has never been convicted of felony before. That has already been filed. We also
So, to the extent the motions of the state that you are agreed to, they're of course granted. And as to the notice of filing of seeking probation, then that of course makes us mandatorily, unless there's an explicit written waiver by both sides, that means this is going to a jury. So what else, counsel?
That's right, Your Honor. We've already elected to for punishment with the jury. Along with that, Judge, I filed a motion for motion in limine. Let's see. I filed that in October 29th of 2019. And I'll send the court a copy. I'll send it to your email, Your Honor, so that you can have it. And I will CC the state. It's just a standard motion in limine.
Well, counsel, you can expect the usual rulings of, that all of us are dealing with. So, but if there is anything specific in there, Madam District Attorney, that we need to address, perhaps we can do that with a conference call, not tie up the real court here any longer. And we have to go ahead, counsel.
And Judge, back when I was initially appointed and Mr. Green was initially indicted in 2019, I had filed my letter of representation, which included requests for my client's complete criminal history for any state's witnesses at trial, any state's witnesses that were going to be included, and a notice from the state of its intent to use any evidence of 404B or extraneous offenses. We have yet to receive those. If the court needs a formal motion, I can make that as well.
Well, that's going to be granted anyhow. But we now play trials like we do poker with all the cards up. There's no hidden cards anymore. Go ahead, counsel. What else?
And finally, Judge, I have filed a motion for continuance on June 18th, 2021. In that motion, as I had stated in the emails to the court, I have a 2-week murder jury trial that begins next Monday on July 12th. We anticipate that trial going all through the next week of July 19th as well. I've asked the prosecutor, Ms. Husky, and she does not oppose this motion.
Well, the original jury setting on this case for this month, that motion for continuance was granted, as I recall, because of we pulled back on the jury panel that was to be selected. So obviously we're not going to trial, and I'm sorry if you didn't get a copy of the order granting, but it's not on for the next several weeks. What else we got?
That's it, Judge. We don't have any other pending pretrial motions.
Okay. Well, when can we understand, Madam District Attorney, you have been talking with the coordinator, and there are some potential trial dates. Can you tell me what those are? And then let's see if defense counsel we can find one that works for everybody.
Absolutely, Your Honor. I have pretrial and trial dates. For the trial dates, Ms. Tabraham was kind enough to give me September 20th as well as November 15th.
And those are the dates you give me, September the 20th, November the 15th. That's pretrial date or jury selection date?
Those are for trial dates, Your Honor.
Okay, that'd be the day we pick the jury.
Yes, sir. The state can pick the jury and start the same day, I do believe.
Okay, well, September the 20th, that's when the state judicial conference is going on, and that happens to be, I'm assigned that week, so.
Okay.
And unfortunately, the calendar that I print just goes through the end of October, so consequently, I don't know about November. Counsel, what's your situation November the 15th?
Judge, I can be ready for this case on November 15th. I have no current settings at all.
Okay, great.
I'll make this a priority.
All right, this is now set for jury selection and trial, November the 15th. All right, what's the pretrial date that, actually, we can do any, because this is the only case I'm working on, and therefore I need to stay out of Mr. Justice Martin's way. And of course, the special prosecutor's got her own docket to deal with. What's the pretrial date?
I have August 10, 12, and 24. I do not have any closer to November. If you would like, Judge, I can reach out to Ms. Tabraham to find those dates closer to November.
Judge, if we can do it on August 24th.
Okay, pretrial's August the 24th. Is there anything else we can accomplish? Madam District Attorney?
I'm sorry, Your Honor.
Is there anything, this is now set for jury selection, November 15th, pretrial. That's August 24th.
Yes, Your Honor.
Okay. Is there anything else we could accomplish?
No, Your Honor, but I would like to inform the court and the defense. I do intend to file an amended indictment. Sorry, I'm confusing my words with my juvenile cases. An amended indictment for this case. I will try and have that for you both as soon as possible, and we'll present it to the grand jury.
Okay.
Amended indictment, or is it going to be?
I'm sorry, you broke up?
Is it an amended indictment, or is it going to be another indictment? You mentioned that you're going to present it to the grand jury.
It will just be an amendment. The charges will be the same. I'm just going to change some of the language.
That can be covered by amendment, correct? As long as you're not changing the real charge there.
Yes, Your Honor.
Okay. Now, counsel, if there's something that we need to address, and if it's things like scheduling or whatever, I'm prepared to do that with conference call and try to avoid disturbing Judge Martin's court any more than outsider like myself has to. Obviously, if there's going to be anything that we need a record on, we can't do it that way. We'll have to try to get everybody assembled really in the courtroom with. Now, but the pretrial, unless the court under tells me otherwise, the pretrial is set for 10. My recollection is jury panels show up in this county at 8:30 in the morning. And if that is a case that, which means is that it's a practical matter, is that I would be involved in the hearing, swearing in the initial jury panel. And consequently is that you folks could be there if you want to. You don't have to be there as far as I'm concerned. But if you want to hear the excuses or whatever, in case you think there might be some error occurring along the way, you just need to be there. My understanding is that it's in the regular courtroom, where counsel and Mr. Green happen to be right now, and not over in the community center anymore. So unless there's something else we can do, is that you'll get the formal notice of the settings. And I assume that is all we can accomplish today. Ms. Husky, is there anything else?
No, Your Honor. Thank you.
Counsel, anything else? All right, well then I'll recess this proceeding. We'll reconvene August 24th, 10 o'clock. Thank you. Goodbye.
Thank you, Judge.
Yes, Your Honor. All right, ladies and gentlemen, when I call your name, if you will say present or here and raise your hand, then we'll move forward with the remaining docket. Jessica Kraft. Troy Burgess. Stuart Hayward. Here. Amy Harmon. Ms. Harmon, I would like to go ahead and get a UA this morning. So if you'll come back here and meet with Ms. Burns before I call your case. William Robertson.
He is in support. It's time to be next week.
All right, we'll take him up in a moment. Tracy Smithart. Ronald Toll. David Jones. Thank you. Is it Miss Broom? I said, is it Miss Broom? All right, thank you. Hippolito Grijalva. Amanda French. Marcus Ellison. Jeffrey Furr. Jeffrey Daniel Furr. Clarissa McMillan. Andrea Pullings. Thank you, Mr. Leader. Dustin Cook.
Your Honor, I believe you filed it.
Yes, I do have that here. Some other waiver of arraignment file. Do you know what pretrial date that's at? I'll look at it. August 10th.
She says,
Ethan Evans. Justin Wright. Jamie Zarate. Or Jaime Zarate. Lindy Delaney. Nathan Sampson. Thank you, Mr. Smart Leader. Samuel Turner. Carlton Mitchell. I've got a note that he is verified in custody in Smith County. Mr. Ashworth is on Zoom. We'll take him up in just a moment. William Wilson. William Wilson. He is in jail? You sure? He is?
Mr. Minor told me this morning. Judges leave.
Good morning, Mr. Ashworth. Can you see and hear me okay? You're on mute, sir.
All right, sorry about that.
Okay.
Can you hear me all right?
Yes, I can. So I've called Mr. Carlton Mitchell. I have a note here that he's in custody in Smith County. Is that true?
That is correct, Your Honor.
All right. Are there any, what was our status for today?
Just to check in and see if he was still in custody.
Do you have any update for the court on how much longer he may be there?
I think a long time. He doesn't even have a first setting date in that county. I mean, so I have his discovery, but we don't have a first appearance date.
All right, let's reset him for another status of custody and. Jeez. I don't want to set it out too long so that he falls through the cracks. So let's look at either August 24th. Are you available on August 24th, sir?
Yes, Your Honor.
All right, so we'll set Mr. Mitchell then for another status of custody on August 24th. Maybe he'll have another, maybe we'll have an appearance date over there and we'll have additional information next time.
Great.
All right, thank you, sir. Appreciate it.
Thank you. I appreciate it as well.
You're very welcome. All right, counsel, do we have anyone that's ready? Mr. Manning?
I got Ms. French, and then also the ones that were asked, Mr. Schoenfeld, you said.
Amanda French, CR 2162.
Yes, Judge, we're here, I received discovery, or we get discovery, I asked for additional reach out to review the videos in this case. And I believe the city is coming.
All right, are you available on August 12th?
Definitely why, Judge. Yes,
Yeah.
I do.
All right, Ms. French, we'll set you for an additional pretrial on August 12th at 9 a.m. Once you receive the yellow copy, you're free to go.
Then Judge, this afternoon for Schoenfeld, is that Brandon Schoenfeld. I went to meet with him last night, and we are not, be able to go for that these days, we asked, we set it to July 29th. He knows his original setting, I had a quick second, and hopefully we can get him taken care of. But it doesn't be
What's the issue on not being able to play the day?
money.
So he's supposed to be bringing money to the plea to,
He's in custody and he's trying to get money from the state. to satisfy the conditions of the agreement.
No objection from the state. All right, so the afternoon docket, CR 18421, Brandon Schoenfield. By agreement, court resets the case for plea on July. I'm not sure, let's see.
We originally set the 29th, for a contested motion to adjudicate for motion to revoke. If we still have one, I'll get it.
If he doesn't have his money by that date, you intend to go forward with a contested hearing?
Potentially ready to go forward.
Okay. All right, then we'll set him on the contested docket on July 29th. And since he's in jail, we'll set that at 1:30.
Thank you, Judge. Thank you.
Yes, sir. Thank you. Anyone else, counsel, you ready, Spring?
Yes, Your Honor.
Let me call it first. CR 21-128, David Ray Jones. Mr. Jones, if you'll come to that middle podium. Mr. Jones is set for pre-trial today. Go ahead, Ms. Spring.
Yes, Your Honor, there are no pretrial motions at this time. I've been working with Ms. Heisel. We are affirming the final details of the plea that would like to be sent to the court. So we're asking for a reset. Ms. Heisel's on vacation. And I anticipate there's just one more issue to work out on the plea.
All right, court will set Mr. Jones for a docket call on August 12th, unless you have a scheduling issue.
They'll be going on vacation on August 11th.
All right, so August 10th. All right, we'll set Mr. Jones in for a docket call on August 10th. And so on that day, I will expect to hear whether there's going to be a plea agreement. If there's no plea agreement by that day, then we can set Mr. Jones for trial. All right, so he'll need to sign this notice of setting. If you haven't done that, you'll need to sign that, and then he'll get the yellow copy and we'll get the white copy. And then after that, Mr. Jones, I need you to come back here and meet with pretrial release for some additional paperwork.
Thank you.
You're welcome. And those forms are right there. Yes, ma'am. Yes, ma'am. Thank you. Counsel, anyone else? Mr. White, are you ready? Hippolito Grijalva, CR 1851, CR 18398. Set for docket call today.
Well, Your Honor, we have been given we've been given a plea bargain that has two components on it. We've made a counter offer. Certain things happen. We need some time to put some things together. We also have some potential litigation conditions, but we think that we probably stay with confident and say we can set this for a plea on July 27th.
Is Mr. Hippolito doing, or I'm sorry, Mr. Grijalva doing a waiver of jury trial today to set for plea, or?
Well, we weren't doing that at this point right here, but we feel confident in come up with we've got some of the options that we think. On the 22nd.
Is this a motion to revoke? No. Yeah, I see it had several pretrial settings before I became judge.
That's great.
Judge, this important date, I believe he was in the hospital, and then it just never got set until I believe the court found it. That's why it's.
All right, court will set Mr. Grijalva for a final docket call on July 27th. And if Mr. Grijalva takes a plea that day, will it be to time or probation?
Either, there are two options, Judge. We have probation or a short. That's discretion.
Okay.
So if we can set it at 9, anticipate that's likely, but not speaking, that's anticipate that's likely what people say, but if not, we can contact coordinator after.
All right, Mr. Grijalva, we'll see you back on July 27th, a couple weeks.
Your Honor, that's all.
Yes, sir. Thank you. Jessica Kraft. It's a probation extension. This is a CR 1847, Jessica Kraft for a probation extension. Ms. Kraft, if you'll raise your right hand. Ma'am, do you swear, yeah, there you go. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Well, you gotta let me finish. You don't even know what I'm gonna say. You gotta let me finish, okay? Do you swear?
Yes.
Okay. Ms. Kraft, you are currently on community supervision, right?
Yes, sir.
And your probation is set to expire this month. And I hold in my hand a document wherein you've signed it, or actually wherein you're requesting that the court extend your community supervision for an additional year. And if the court approved that, you would have to pay probation and your analysis fees during that additional year. Why do you want your probation extended?
I'm gonna stay for a year. I haven't even reported for this month yet. I didn't know it was extended for a year. I talked to my probation officer about it.
Well, why don't you go talk to your probation officer and then come back to court?
Okay.
I'm just gonna leave it here because I've already signed it. For the record, this is Tracy Smith Hart, CR 21145. All right, Ms. Smith Hart is set for pretrial today.
No formal pre-trial.
Are you available on August 10th or 12th?
Yes, sir. 10th, yeah, well, y'all got to be at the jail, yeah. I can do the 10th, I've got 3 cases set in the 86, with that morning already off and stuff. You could be 10:30 or something for it. But if you're on 7th, check up.
What does the 12th look like?
Worse.
Worse?
Judge, I mean, coughing that thing too. 2, 3, 4, 5, 6 cases.
All in the morning?
Yes, all in the morning. Yes.
All right, we'll set Ms. Smith Hart then on. What about August 24th? That'd be better.
Yes, sir.
All right, we'll set Ms. Smith Hart then for docket call on August 24th at 9 a.m. Ms. Smith Hart, once you sign your notice of setting and get the yellow copy, you'll be free to go. Mr. Toll, CR 21146, Ronald Darren Toll. Mr. Toll is set for arraignment today.
Please support, my client advised that the information house of those charges. So his name is spelled correctly. We will wait and read it again.
All right, the court will enter Mr. Toll's plea of not guilty into the record. We'll set him for pretrial on August 24th at 9 a.m. Yes.
He's the one that's
State, do you want to approach as well?
I just found out about this yesterday.
This is CR 21142 and CR 21151, State versus William Roberson. Mr. Roberson was set for pretrial today. Is this the case that we recently understood that he was going to be going to Senate court, or was that a different case?
With a different case.
Okay.
That was, he was the, Mr. Hawk on, not two.
That's why.
No, it wasn't that one.
Anyway,
It was a different case. Yeah, it was a different case.
Judge Harris is never considered court, and I didn't know about this until yesterday, when his wife called to tell me that I called and actually talked to him at Senate court. And he's supposed to be released on July.
When does it say when he went in?
Yes, sir, it does. June. I didn't. June the 8th, right after court last time.
State have any objection to today's hearing being reset for a couple of weeks?
No.
Are you available on the 27th or the 15th? Probably the 27th, so that if he's being discharged.
Judge, I'm on vacation that week.
The 27th?
Yes, sir. The 26th through the 2nd of August. Yes.
Well, let's set him then for the 15th, and we'll get an update on him.
July 15th.
July 15th. For pretrial and status on Senate floor. Because it says projected. We know what projected means. But if he is in drug rehab, then he must have a drug problem. And if he has a drug problem, that's where he needs to be. So
That's kind of what I thought. And I have one more case, Judge, but she's taking it.
just let me know. Mr. White, are you ready?
Yes.
Would you like to call first? Justin Raymond Wright, CR 21148. Mr. Wright, just right there at the podium is fine. All right, Mr. Wright set for pretrial today.
Yes, sir, we found pre-trial motions. We're operating off the full standard. So we'll have additional
You have any scheduling issues in August, Mr. White? Right now, I'm setting for August 12th or August 24th. And if you have any, if you're already going to be here on the 10th, we may be able to accommodate that as well. I'm not sure what your schedule looks like. I used to have software that would tell me when you're going to be here. I could track you like the government does, but don't have it anymore.
We can do
You'll be here on the 10th. You want to do it? Okay. All right, then we'll set Mr. Wright then for docket call on August 10th at 9 a.m. Mr. Wright, you're free to go. Yeah. Ethan Evans, CR 2117, CR 2145.
after agreement and he kind of tweaked it a little bit. And I think the district attorney's office down there. Whoever, we, so, let me just set this. Okay. You have, I'd like to do it as much as possible. I believe you have a 27th document that can you do that.
Sure. All right, Mr. Evans, we're going to bring you back so we can get your paperwork done on July 27th. That'll be at 9 a.m. Once you sign the form and get your yellow copy, you'll be free to go. Jaime Zarate, CR 2278.
Mr. White, I oppose this.
Yes. You went on the record.
We had said this for, we've already waived. This is mainly a restitution issue. And Mr. Woodblock informed me that it's not going to affect what we do from a police standpoint. But the restitution issue got a little complicated because
You're,
yeah.
Mr. Zarate has a co-defendant that we have previously dismissed because he was deported. We now have information that he has come back. We need to re-indict the co-defendant. And likely we'll need to figure out the restitution is joint and several, something of that nature. We need to get the other co-defendant indicted so we can make sure the paperwork matches. We're not gonna be able to get him indicted until the end of the month. So if we can have this set just beyond that, so we can have, make sure the paperwork all matches and we can get everything figured out.
If the restitution is going to be joint and several, whether you indict him or you don't indict him, the end result's the same. It's joint and several.
That's part, we're kind of on our side a little bit about.
Y'all don't want to pay if someone else is going to come in and pay.
Without going into facts, because I'm not going to hear too much, but this is a rather situation. The state is, I think, a little bit of an unusual position here. And because there's a possibility that you can make, we're discussing, it's just complicated. I think if there's
Around the situation's extremely odd. The state believes it can proceed. It will be extremely difficult for the state to proceed, but we can. We're trying to work a just resolution for the victim and for both defendants. We just need a little bit more time to try to do that.
But he may not, your co-defendant may not be indicted for more than 60 days.
He will be indicted this month.
The end of this month?
Yes, Judge. Myself.
All right, so what, proposing like end of August?
Middle is perfectly fine. We will have a resolution one way or another by then.
So August 10th.
That's
Just put it back on that same date that you're going to be here. I mean, it's
I
only
mean, like I
30
said,
days.
this has just been one of those, every time we think we got this one worked out, it's been one for something. I don't know why. Why do the, but you don't want to hear it.
All right. All right, due to the request and agreement of the parties, the court's going to reset Mr. Zarate to enter a plea on August 10th at 9 a.m. Once you sign your notice of appearance, get the yellow copy, you're free to go. So you have. Okay. State versus Nathan Joseph Sampson. All right, Mr. Sampson, if you'll raise your right hand, I'm going to place you under oath. Mr. Sampson, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right. Make sure you speak up loud enough for my court reporter to be able to hear you. And Mr. Murray Leader, if you want to turn on that microphone and bring it closer to him, that may help. Yes.
Make sure it's an amended indictment. There's an amended indictment in this case. I just want to make sure that the correct one got printed out and put in.
This needs to stay with him. He needs to do that to Schwab. He keeps that. Here, do you want to pick the clipper up?
The processor would yell at me.
Yes. We're on YouTube.
She yelled at me before for that, so.
Yes, please.
Indictment. Okay, yes, Judge. Okay. I was just checking to make sure that the amended indictment got there.
Yeah, Lori told me she'd live with
Judge,
She made sure I was aware as well.
if you could speak up, he's really hard of hearing.
I'll tell you what, bring him up. Just bring him up here to this blue. All right, Mr. Sampson, is this better?
Yeah.
Okay. All right, your name is Joseph, Nathan Joseph Sampson, is that right? And Mr. Sampson, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Shavnesh Murleader. Are you pleased with his representation of you? Feel like you've had enough time to discuss your case with him and have all your legal questions answered? Is there anything about the paperwork that you've read and signed today that you do not understand?
No.
Mr. Murleader, do you believe your client to be competent today?
Yes, Your Honor.
You've explained to him his legal and constitutional rights.
That's correct, Your Honor.
Mr. Sampson, you're charged by indictment with a third-degree felony offense of possession of child pornography, which carries a range of punishment of not less than 2 years or more than 10 years confinement in TDC and a fine not to exceed $10,000. It appears here that you want to enter into a plea agreement with the state of Texas in which you would be pleading guilty to that charge in exchange for their recommendation that this court assess punishment at 10 years confinement in TDC, with that being suspended and you being placed on community supervision for 10 years with a $1,600 fine, $290 court cost, $935 in reimbursement fees. Is that the plea agreement you're asking the court to approve today? All right, Mr. Sampson, understanding the plea agreement and the range of punishment, how do you plead to that offense? And Mr. Sampson, are you pleading guilty to that because you are guilty of committing that offense? Has anyone threatened, forced, or pressured you to plead guilty?
No.
All right, court will accept the defendant's plea of guilt. Mr. Murleader, any objection to states one?
No, Your Honor.
States one is admitted into evidence. And the court does take judicial notice of Mr. Sampson's judicial confession. Anything further from the state?
Yes, Judge, we would offer to the court that we are in compliance with victim notification. We've sent out the impact statements and have received no response from the victim.
Anything further from the defense?
And Judge, we had no objection to the state's one exhibit. That included admonitions for the sex offender registry, which I went over with Mr. Sampson, paragraph by paragraph, which he initialed. And I'm also going to give him a copy of chapter 62 of the Code of Procedure. He's been admonished of his requirements for the sex offender registry if the court accepts this plea.
Thank you, Mr. Murleader. All right, based on the course review of the evidence, I do find there's sufficient evidence to convict Mr. Sampson of this offense. The court will follow the plea agreement in this case. Court convicts Mr. Sampson of possession of child pornography, assesses his punishment at 10 years confinement in the Texas Department of Criminal Justice. Court will suspend that sentence, place Mr. Sampson on 10 years community supervision. Court assesses a fine in the amount of $1,600, court costs of $290, reimbursement fees of $935. Court finds that this is an offense prosecuted under Chapter 62 of the offense of the Texas Code of Criminal Procedure. Court finds that the age of the victim at the time of offense was 15 years of age. Court also finds that Mr. Sampson has been admonished of his requirements pursuant to Chapter 62, sex offender registration, and has been provided a copy of Chapter 62 by the state. All right, Mr. Sampson, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you be fingerprinted by my deputy here. After that, report over here through this door to probation. Mr. Merley, are you ready on Mr. Turner?
Yeah, sure.
Mr. Turner? Samuel Adam Turner, CR 21147. Just come up here to this podium here in the middle, sir. Mr. Turner is set for pretrial today.
Yes, Your Honor. About a month back, I filed a motion for discovery of the state. The state has agreed to reset our pretrial so that they can comply with the requirements of discovery. We asked for one other pretrial date in order for the state to do that.
Was there a delay in providing discovery to Mr. Merley?
Judge, it asks for specifically criminal defendants, which will have warrant for that. And also apparently there's a body cam video that doesn't have it says that we don't have seeking out to.
All right, Mr. Merley, are you available on August 12th?
Judge, those are going to be 12 weeks. The courthouse time on
No, that's a trial week. About August 24th. 24th? All All right, Mr. Turner, I'm going to set you to appear back before the court on August 24th at 9 a.m. Mr. Murray Leader, I do show that Mr. Turner has a growing delinquency on his bond supervision towards attorney fees and bond supervision fees. So I'd ask that you admonish him. And then Mr. Turner, before you leave, I want you to come back here to the pretrial release department. Did you make payments today?
Yes, sir.
How much did you pay?
60.
Okay, I show you're delinquent 230. So I need you to make a better effort.
Yes, sir, I just started. Security. Just check.
Okay. All right. Well, I appreciate the payment. Just see if you can't get that caught up before we come back on August 24th.
Yes, sir.
No, that's okay. All right, Mr. Turner, since you made a payment today, you're free to go.
Thank you.
You're welcome, sir.
Which I'm already on Mr. Maddox cases too.
Okay. Larissa McMillan, CR 2184. Ms. McMillan is set for pretrial today.
Thank you, Your Honor. Mr. Adams is currently in West County announcing for control there. He asked me to announce for Mr. McMillan that he hasn't had enough time to finish reviewing the discovery for this case and seeing if he can file pretrial motions requesting other pretrial hearing for this case. State.
Do you know his calendar?
But if you want to schedule it for August 24th,
Well, I was thinking August 12th.
if you can put August 12th, that's fine. I think that he will be fine.
Since there's no objection from the state, court will set Ms. McMillan for an additional pretrial on August 12th at 9 a.m. And Ms. McMillan, you'll need to report to pretrial release before you leave today to sign your pretrial release papers. Andrea Pullings, CR 21-140.
Currently in West County, he has asked for additional time to review the submission of discovery, seeing if he can file pretrial motions. I've asked the state to get it.
All right, court will set Ms. Pullings for another pretrial on August 12th at 9 a.m. You're free to go. I'm not sure if she's given one yet. I see her drinking water over there, so I'm assuming she hasn't given one yet. Mr. Stevens, are you ready on Ms. Harmon?
She is taking a drug test.
Well, I see her back here, so have you already taken that test, Ms. Harmon?
Let me visit her, just real quick.
Okay.
See if Ms. Harmon is taking her drug test. Ms. Harmon, take her drug test.
This is CR 21-121, State versus Amy Beatrice Harmon. We're set for pretrial. Go ahead, Mr. Stevens.
Judge, we have no formal pre-trial notice.
All right, we'll set Ms. Harmon then for docket call on August 24th at 9 a.m. Shut up.
I've got cases he called with things this afternoon. We're trying to get Brad to do my Anthony.
Here.
Yes, sir. No, sir, in Anthony.
Oh, okay.
Be here, but
I'll be just a little bit late.
Okay.
Because I have to do the 86 first. I've got two please.
Okay.
So I just,
And this is a docket call. So you just got one, right?
yes, so that's it.
Do you know what you're doing on that one or what she's doing on that? Or you got to talk to her?
I think we'll probably end up making, just to be honest with you, I did tell them.
So you talk to her. Okay.
I
Okay.
think we're.
Okay. But we got several others. So by the time you get there, it'll be all right.
Right, I just wanted to know. I'll make that. So,
Appreciate it.
thank you. Bye.
Yes, sir. Have a good lunch. Mr. Murray, all you have left is Miss Delaney, correct?
That's right.
All right. All right, court's going to stand in recess until I get Miss Delaney's drug test back and Miss Thompson and Mr. Weiner appear. So they've indicated to me that they're going to be late. They didn't say when, so we're just going to wait on them. Okay. So if you want to, you can step out and call their office if you want to know when they're going to get here, because I don't know. Yes, sir.
consulted with my client, she was not going to accept the state's plea offer of 10 years to pay. I have filed no pretrial contested motions, but I have filed an application for probation in both cases. Most likely, we're going to be electing the jury question in both cases. Mr. Delaney is requesting a jury trial in both cases, and I think the state is going to designate the manufacturing delivery days as 20 days for trial. It's license case, which is not here today. And I have been in contact with Mr. Delaney. Mr. Delaney is not responding. Do it over the paperwork, and she is requesting jury trial.
So what were the offers that Ms. Delaney rejected in each case?
The judge, we didn't receive an offer for the state judge on the case because it's nice and offer to take that into consideration with the 10-year offer for the CR 20 case.
So is a 10-year TDC with a 1245 of the state jail? And that's what she's rejected?
That's correct.
And state, is that the best offer that's going to be made to Ms. Delaney?
Yes, sir.
All right, court, and Mr. Merleader, you're ready to go right to the jury trial docket on the state jail felony also?
Yes, Judge. But like I said, I think the state is going to designate the possession case. Sorry, the manufacturing delivery case.
All right, the court will set Ms. Delaney for jury selection on August 2nd in each case. And she'll remain on the docket until she is selected for trial. And you'll obviously receive a notice, Mr. Merleader, if she ends up in the court's top 10.
I'm not informed Ms. Delaney that if she's on the jury, not if she has the court, basically the courthouse, get a reset, so we actually are going to trial.
All right, Officer Matura, if you'll step forward here. All right, Officer Matura, I directed Ms. Delaney to submit to a urinalysis drug test. Was that performed today? All right, I'm going to swear you in. If you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right. And so, Officer Matura, did you administer the UA drug test to Ms. Delaney? And what were the results?
She tested positive for marijuana. She admitted use of marijuana. Denied consent.
And was the admittance to marijuana before or after the drug test? Before the drug test. Mr. Merleader, any questions of Officer Matura? Mr. Woodwhite? All right, Ms. Delaney, the court's going to find you in violation of your conditions of pretrial release. Court's going to find your bail insufficient in each case. And the court's going to set new bail. Court's going to set new bail in CR 2399, second degree felony at $50,000 and the state jail at $25,000. Deputy McLeish, I ask that you take Ms. Delaney into custody at this time. Mr. Merleader, do you have anything further? Mr. Weiner?
Yes, Your Honor. I'm ready.
All right, court calls. Marcus Ellison, CR 2161. Mr. Ellison set for pretrial today.
Yes, Your Honor. We received all discovery for this day. We have that's a pre-trial motions for report at this time. We ask you to move to the docket call.
All right, Mr. Weiner, are you available on August 12th? All right, we'll set Mr. Ellison for a docket call on August 12th. Mr. Ellison, once you sign the notice of appearance and get the yellow copy, then I need you to report over here to pretrial release. They have additional paperwork for you, okay? Mr. Furr. CR 2078. State versus Jeffrey Daniel Furr. Mr. Furr also set for pretrial. You can come on, man.
She good?
All right, go ahead, Mr. Furr.
Judge, for some reason, they had different lawyer attached on the first case, so I have not received discovery. I spoke to the lawyer this morning. We should have that correct. I'm gonna check when I get back to the office. This is our first pretrial, so I'm gonna ask for a second one, so I have time to do that.
Mr. Waddell do the test.
Mr. Waddell, if you'll step forward here. Before I set that, Officer Waddell, if you'll raise your right hand. Officer Waddell, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right. Officer Waddell, did you administer a UA drug test to Mr. Furr today? And what were the results of that?
Results of the test was Mr. Hudson report.
And did you discuss that with him?
Yes, sir.
And what was his response?
He denied that he used weapons.
Did he provide you any information as to why it may result in a positive test, such as any type of prescription medication or anything else?
He just said that he had shown in the past.
Mr. Weiner, any questions for Officer Waddell?
Mr. Waddell, Officer Waddell, you're going to send that off for confirmation, is that right? Yes. And there's certainly been times in which somebody gets tested positive and confirmation has ruled out that somebody actually tested positive.
It is possible.
Did you ask him specifically about any prescription medications or any over-the-counter medications?
Not specific. We did.
Okay.
Until we took antibiotics. So it was specific.
Okay.
Mr. Woodwike, any questions for Officer Waddell? Thank you, Officer Waddell. You're free to go. You can certainly ask it. Of course, going to deny your request. I'm going to find Mr. Furr's bail to be insufficient in this case. Officer, I'm going to ask that you take Mr. Furr into custody for violation of conditions of pretrial release. The court will send that off for confirmation. And obviously, if the court receives any type of result that is contrary to the testimony today, the court will reconsider bail, most likely without a hearing.
I understand.
We'll reset Mr. Furr for pretrial on August 12th at 9 a.m. I got to see what his current bill is. You know what Mr. Furr's bill is. Did just, I'm gonna set Mr. Furr's bond at 40,000. It's doubling.
And then actually, if I could revisit Mr. Ellison, he comes from Tennessee, every time he comes forward, is there any way we can get a setting that's a little further out? To accommodate his travel that?
What about him just appearing via Zoom?
That's.
It's a pretrial setting. I have no problem with it if state has no objection.
Thank you very much. I appreciate it.
You're welcome. 40 for, I'll double check these. I'm going to make an amendment to the bail amount for Miss Delaney and cause number CR 20150. I believe Miss Delaney's bail was already set, was initially set at 25,000, and then release of surety resulted in a $100,000 bond, which she made. So the court's not going to reduce bail for her in this case. So the court's going to set it at 150,000. I still want this for confirmation though. Set a time for him. She says she's got copies to go behind all that of the drug tests. Ms. Thompson, are you ready?
I'm ready on this bird.
Mr. Burgess? And sir, if you want to come with him, you can. Y'all just come to the podium here in the middle. Hmm.
How you doing?
Good, good. How are you?
Fine.
Making the rounds, making the rounds.
I don't have this to make a history yesterday. It was very interesting.
I want to hear about that. This is CR 21-8, State versus Troy. Wayne Burgess set for pretrial today.
Your Honor, we had a competency evaluation done on him, was real competent. However, at the interview with Mr. Burgess for a considerable time this morning, and with his father and stuff, we're going to ask this to be reset so that we can seek a second mental evaluation on him.
Do you want to contest the evaluation, or is your client going to pay for a second one?
Well, his father says that they will pay for it if they have to, and I can't give them a price right now without first talking to the doctor, because we want Dr. Bartolow's.
Okay. And I just want to be clear that once the court-appointed expert gives his report, if there's no contest to it, I'm not going to just summarily grant a second request. But if there's a contest to it and there's a reason that report is insufficient or is in error, then I would consider a second one. Otherwise, I would expect the defendant to bring forth, if he wants his own testing, to bring forth the money for his own testing.
Okay.
So I don't mind resetting the case for the family to consider that.
Right. Well, let's do that because it's difficult communication somewhat with my client, and I want to make sure through the dad that he understands they could do this. Okay.
All right. Let's see. Are you available on August 24th? I'd say that a little bit
Yes,
longer.
sir. Yeah, I believe that will be fine with me. I don't really have a lot set for the August 5th.
All right, we'll set this for status for defendants.
And I'll go ahead and talk to the doctor and I'll get a price, and I'll let, in my filing, I'll let the court know whether they're going to be paid for that or not. Is that okay?
Whether they'll be able to pay for it?
Yeah.
Well, I mean, Mr. Burgess has been found indigent.
Yeah,
So I'm telling you that if you send in a request saying, we want a second one and they can't pay for it, then I need to know why the first one
Well,
is
let
not
me-
sufficient.
yeah, I understand. If they cannot pay for it, they will ask for custody hearing.
Okay, Okay, I just want to make sure we're on the same.
Right,
page.
right, we're on the same page.
All right, so that's going to be set for August 24th.
All right.
So once Mr. Burgess signs, then he is free to go.
All right. And court will give you just a few minutes to speak to Mr. Haywood. I
Yes.
appreciate that.
Absolutely.
Can I show you about this deal yesterday?
Yeah, let me This is cause number CR 21-122, CR 21-149, State versus Stewart James Haywood, set for pretrial in each cause.
Your Honor, we reached an agreement with the states, we just need separate.
Okay. I've got you, let's see, we don't have you coming back on Burgess, 824. Is that too long, or you want to do it sooner rather than later?
I think for Haywood, when the new job was started, probably also.
Is that better for you, Mr. Haywood? I mean, I can get you in sooner. Okay. All right, then we'll set Mr. Haywood then to enter a plea before the court on 824. Is that to probation or time or probation? And Mr. Haywood's, you don't live in the state of Texas, do you? Oh, you do? Okay. All right. Oh, okay. No, I thought earlier he said something to me. I thought he said he had something up in Chicago or something. Mr. Haywood, just, did you tell me earlier before Ms. Thompson got here, were you telling me something about Chicago, or did I hear that wrong?
No, my sister just passed, that's where I'm from, and the funeral was tomorrow.
Okay, I guess I just misunderstood. So, all right, you're free to go. No, you don't need to talk to them right now. You'll come back on the 24th and do all your paperwork, and you'll talk to probation that
I
day.
think what he's asking, I was going to make sure he won't get in trouble because his sister,
Oh, is that out of state? Where is that at? I knew I wasn't crazy. Yes, you can go back here and meet with Officer Mature and Ms. Burns. You're welcome, sir.
Your Honor, that's all I have.
Yes, ma'am. Thank you.
Much better now. I feel like this. I'm like,
Doesn't have to be long, you know, this-
not too rough.
All right, are we ready on Mr. Wilson?
We are, Judge. The paperwork is signed by everybody, obviously, except for you. When we're done with the plea, I'll have him fingerprinted, and then I'll carry the paperwork back to you at the courthouse, if that's okay.
Yes, sir. Yes, sir. Can you go ahead and take me through what the terms are? Is he pleading to each charge, or is there going to be some 1245s?
So, Your Honor, he's pleading on the tampering case. It's 327. The other two are being considered.
Okay.
It is a 6-year TDC sentence with a $1,500 fine, and he has 398 days credit.
What about court?
Yes, sir. $290 in court cost. And then there's medical restitution in the amount of $1,243.38. I've admonished him of the range of punishment of a 3rd-degree felony, but also his potential status as a habitual offender, though it's indicted just as a straight-up third, Judge.
Okay, so is the state abandoning the enhancements?
It's just indicted as a 3rd-degree felony, Judge, so there aren't any enhancements at this point to abandon. But I've explained that to my client that they could file a Brooks notice.
Okay.
Yeah, the
Does
state
that make sense?
enhanced all, he has not been enhanced.
Okay.
Proceeding this charge.
Any other reimbursement fees other than the medical restitution?
Judge, let me look at the face of the judgment. It doesn't designate what it's for, but there is a $15 reimbursement fee. I'm not sure what that's for, Judge.
Okay. And it's probably on his bill of costs. It could be on the second page. All right, Mr. Wilson, if you'll raise your right hand, Mr. Wilson, I'm going to place you under oath. Mr. Wilson, swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? I can't hear you.
Yes, sir.
Okay. All right, you can put your hand down. Mr. Wilson, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
Mental health, have you ever been diagnosed? Just tell the judge why you've been diagnosed.
Yes, sir.
Okay, what have you been diagnosed with?
This severe anxiety, panic attack disorders and bipolar.
Okay, and Mr. Wilson, are you currently on medication or undergoing treatment for any of those disorders?
Yes, I've taken medication.
All right, do you feel like that medication is helping you today and giving you the ability to have a rational understanding of the proceedings against you?
Yes, sir.
You understand everything that's going on in court?
Yes, sir.
Okay. And are you pleased with Mr. Weiner being your attorney?
Yes, sir.
You feel like you've had enough time to discuss your case with him and have all your questions answered?
Yes, sir.
Is there anything about the paperwork that you do not understand?
No, sir.
And where you have signed that paperwork, are you telling me that that is your true and correct signature?
Yes, sir.
Okay. And you heard Mr. Weiner read the plea agreement out on the record. Is that what you're asking the court to approve today?
Yes, sir. Yes, sir.
All right, Mr. Wilson, you're charged by indictment with a third-degree felony offense of tampering with or fabricating physical evidence, which does have a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice Institutional Division, and also carries an optional fine not to exceed $10,000. Understand?
Judge, it's 2 to 10. I'm sorry, Judge, but it's a 2 to 10 on a third.
Is that what I said?
I believe you said 2 to 20.
Oh, did I say 20? Oh, I did say 2. I'm sorry.
I'm not sure.
No, it's no big deal. I'm sorry to interrupt you, Judge.
No, it's okay. It's okay. If I did say 20, I apologize. Yes, it's not less than or more than 10 years confinement and a fine not to exceed $10,000. So I see here that the proposed plea agreement at 6 years and a $1,500 fine would fit within that legal range of punishment, Mr. Wilson. So let me ask you then, how do you plead to that charge?
Guilty.
Mr. Wilson, are you pleading guilty because you are guilty of committing that offense and for no other reason?
Yes, sir.
All right, the court will accept Mr. Wilson's plea of guilt. Mr. Weiner, any objection to States 1?
No objection, Judge.
All right, States 1 is admitted into evidence in this cause. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Judge, just a quick recitation of facts. Mr. Weiner, can you hear me?
Barely, but we discussed earlier. I know what you're going to say.
Judge, just briefly, the facts of the case are Mr. Wilson and girlfriend will be investigated by Sheriff Stephanie. The girlfriend got into an interaction, altercation with the officer. Mr. Wilson, I believe, was outside the vehicle. He got into the vehicle, threw out a bag of marijuana, which is the tampering. That's the evading is being considered. Those are the facts underlying out of the vehicle and then drove off while his then girlfriend was assaulting an officer.
Thank you, Mr. Woodwhite. And I'm not sure if you heard that, Mr. Weiner, but you said you have no objection to his recitation of the facts.
We did hear, and I have no objection.
Okay, good. All right. Was it a misdemeanor amount of marijuana? So it would have been a misdemeanor arrest at most?
Yes, Your Honor.
But now we have a 6-year TDC sentence on a third-degree felony.
That's correct.
That's very unfortunate. All right, anything further from the defense, Mr. Weiner?
No, Your Honor. Ask the court to follow plea bargain.
Okay. All right, then based on the evidence presented to the court will follow the plea agreement in this case. Court finds Mr. Wilson to be guilty of the third-degree felony offense of tampering with or fabricating physical evidence. The court assesses his punishment in accordance with the plea agreement at 6 years confinement in the Texas Department of Criminal Justice, assesses a $1,500 fine, $290 court cost, $15 reimbursement fee, orders medical restitution in the amount of $1,243.38. Court takes into consideration under section 1245, cause number CR 18521, and also cause number CR 19327. Court awards Mr. Wilson 390 days, towards his sentence for the time that he has spent in jail on this cause. Mr. Wilson, I'll have you fingerprinted on the judgment, and then you'll be remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Once you are released from TDC, Mr. Wilson, I'm going to order you to report to the Van Zandt County Courthouse so you can make arrangements to discharge your fines, court costs, and fees, okay?
Yes, sir.
All right. Good luck to you, Mr. Wilson.
Thank you, Judge. I'm going to get my client fingerprinted, terminate our end of the Zoom meeting, and then run these paperwork to your office.
Go ahead. Yeah, go ahead. I'll shut you down on that side for your Zoom. And so if you'll just help him get fingerprinted, I appreciate your help.
I got it. Thanks, Judge.
You're very welcome.
All right, hey, we'll just do one, just your right thumb. Right? Just put it straight there. All right, and then just put it straight, look straight up. There you go. All right. Appreciate you very much. I think we're all done. Yeah, let me turn this on.